Hello, everyone. My name is Joshua Gilliland, attorney blogger on Bowtie Law. And with me today is my friend David Cochran, who is the Chief Operating Officer at Planet Data. And we're going to talk about issues pertaining to the duty of competency and project management as we think about insourcing, outsourcing work, and co-sourcing work. Dave, how are you doing today?
I'm doing great, Josh. How are you?
Outstanding. It's a beautiful day in California, and all is well in the world.
That's great. Beautiful day here in Pittsburgh.
Outstanding. Look forward to visiting again soon. Well, let's talk about the different forms of sourcing that we can have in a law firm. For our audience, how do you define insourcing?
Well, Josh, I define insourcing as when law firms and corporate legal departments take a lot of the services that have been traditionally outsourced and bring them inside. And typically that can be from management of an overall project to data collection to ESI processing to data hosting on whether it's either on a law firm or a corporate technology site, as well as then managed review services.
So let's define what services normally would be insourced with a firm.
Well, what we've seen over the past several years in trending is that the management, where the law firms will hire experts to, whether it's a special counsel or a litigation support professional, they'll be brought in to manage any types of small projects, whether it be for data collection, processing, and even manage review. And sometimes these services also include hosting, where the firm will utilize a database package like a Relativity or any of the other types of packages that are out there, and they'll manage it there in the firm, or they'll utilize the corporate's data center for managing the hosted review.
Now, for our audience, what are the advantages of bringing those functions in-house?
Well, I think there's several. I think one, in talking to a lot of our clients, is that they feel as they have much more control, that they're involved in the process going forward, as well as the ability to maintain touch points with the suppliers, as well as then being able to clearly communicate to their clients on what's going on with the project and adding in their consulting expertise as required going forward.
Well, let's think about the disadvantages when you brought the work in-house and you're controlling it in-house. One jumps out at me is you actually have to know what you're doing, and that means investing in the knowledge to do so. What are some of the disadvantages that you see firms having in bringing the technology in-house?
I think that's a very good point, because it's the same issue when a supplier is looking for good domain experts to come in. The firms have to hire that person. In addition, you have the infrastructure and logistics surrounding any types of insourcing that you may have. You have to buy computers, you have to hire support staff, and it's not a 9-to-5 typical job. So you've got to have a support team that can support the legal staff, basically 7 days a week, 24 hours a day. And so, one of the disadvantages is having that staff, making sure that they're trained, they're experts, but as well as then you've got all that additional cost that the law firm has to bear. And whether they then decide to pass those costs along to their corporate client is a decision by the partnership at the firm. And thus, you need to make sure you've got a lot of work in order to sustain that team, that infrastructure, all the administrative issues and items that surround that whole area.
One thing that I see as both an advantage and a disadvantage is in my past jobs, I've been at some of the software companies that sold a product to law firms. One of the big challenges we had with those firms was the attorneys and sometimes the paralegals not learning how the application worked. And they would blame the application for not working because they never learned how to use it. So I would see as an advantage in that situation is having the folks in-house who can help instruct and mentor and teach the lawyers actually how to use the product as being a huge benefit. But the disadvantage is you have to have people who know how to use it. And if you make the investment and you don't have the underlying knowledge, you have problems in the long run because people aren't using the tool correctly. It's my favorite mantra of using a screwdriver to butter toast, because they don't know what they're doing with the application, and they develop really weird workflows.
Well, and I agree, and I think that's why it's so important that if a firm is going to insource a lot of these services, it's got to be bought in by the management committee of that firm. And then it's got to be a very disciplined approach that, the lawyers, the partners utilize that inside group, as well as then abide by their expertise and direction going forward.
Yeah. So, well, let's talk about the other point of view, which would be outsourcing. And let's define that for our listeners, please.
Sure. Outsourcing, traditionally is when a firm does not have the ability to do anything in-house, and they're outsourcing all of their services, which, as I talked about a few minutes ago, can be from anywhere from data collection to processing to hosting to managed review to consulting. It goes back into the 1980s when everything was outsourced and there were no real capabilities inside the law firms at the time. And so, what we're finding right now, we're seeing trending over the past, I would say 7-8 years, is that, the outsourcing model, pure outsourcing model, is going away, and you're seeing a lot more of a co-sourcing approach to projects.
Well, let's define what co-sourcing would be so people can, because it might be a new term to a lot of folks.
Sure. I look at co-sourcing in a couple different definitions. One is where a law firm has recognized that they have certain domain expertise that they're going to retain in-house, and they've decided for business reasons that they're going to utilize a vendor or a supplier to provide the other components of a project. And it's the same ones we've talked about here in the past. And I think what that allows then is to each entity, providing their expertise, their consulting, and really making it a much more cost-effective approach for the client. And I think the second part is that in co-sourcing, we're seeing a lot more involvement by the corporate legal department with the law firm, with the supplier. So you basically got a trifecta of people involved in making projects go forward. And I've seen that only in the past 3 to 4 years, which to me is a very new trend, which is, I think, born by big data and really pushing the reduction in cost going forward.
Yeah, and I've seen it as an interesting mix, because I've seen a lot of the mega companies bring in collection, and they might be using an archival system that has early case assessment built into it, and they either maintain everything themselves, including the people to do it. I've seen some that own all the technology but have a master service agreement with a service provider to take care of it for them. And then when it's farmed out to the law firm for litigation, they might be using a hosted review platform that's hosted by the client for review. And I've seen other, go in the completely opposite direction, that it goes from our archival system to hosted review either at the firm or to a service provider. And one of the advantages with the service providers is there's normally a project manager assigned to the case to help them figure out search terms, how to respond to discovery requests, that sort of workflow.
Right.
So it's kind of fascinating to see how it's going.
No, and I agree. And I think I'll give you an example. We have a client that has a team of project managers in-house. It's a major law firm. They are hosting a platform, have a hosted platform, and we will be doing the processing and the ECA for them, with them involved in the ECA aspect. Data is then loaded onto their platform, and they then do productions internally. They're set up very strategically, with enough staff and investment to do that. However, when they do have certain situations where, whether it's a joint defense group or other mandates, we will then host that data for them, and then eventually transfer the data to their in-house. So, I think a good couple of key factors in co-sourcing in general is you've got to have a lot of trust. Not only trust in what you can do inside of a firm or corporation, but trust with your suppliers. And it may not just be one supplier that provides the particular service. That may be one provider that provides data collection, one that does the processing, one that does the hosting. All of those different things are brought together in a very seamless foundation of good project management, as you talked about in your opening.
So, and I agree with everything that you've just said, and it's interesting watching kind of the scales that we're seeing. So there are national size firms that I've seen, and also the big regional ones that might cover several states, that will have e-discovery counsel, and their job is to manage their e-discovery, and I've seen it in two flavors now. There are the times when e-discovery counsel is basically the master of all the outsourcing, so everything on the law firm side to the service providers goes through that individual, and that team is managing everything. So that's part a co-sourcing model. There are other ones where they have hosted solutions themselves, and they are managing things in-house that they are controlling, and they might put some of the larger matters, maybe interstate matters or complex multi-district litigation, out with one of the other service providers. And there's absolutely no one formula that I've seen. I've seen a lot. And then you get to some of the mid-sized and the smaller firms. I've worked with a couple and basically kind of playing the role as e-discovery counselor, project manager, and explaining to the attorneys, this is how you should do it. And this is, and acting as a translator to the service provider, because the lawyer knows what they need to do legally, but they don't know how to verbalize that information to the service provider in a way that the service provider understands what they're trying to do. So there's that language barrier between both sides.
And I agree, and I think, I think you hit it on the head with the co-sourcing with the small to medium firms. With a good co-sourcing model with an expert inside there, or even an outside consultant serving in a role as an inside person working with outside suppliers, that allows that small to mid-sized firm to be on par with the larger firms that may have more staff. They're just utilizing the outsourced or the co-sourced approach in order to leverage and be able to make presentations to larger corporate clients that, hey, look, we can handle this, and here's how we can do it. And it's a very systematic, thought-through, processed approach.
Which reminds me of the proposed California ethics opinion that we have on electronic discovery that's pending right now. Public comments open through the end of June, and it's fascinating to look at. And I haven't looked at all the comments yet, and I don't know if it's going to go through or not, but I think it should. That's my 2 cents, because there are several messages to take from it. One, it's part of your duty of competency to understand e-discovery. And if you don't understand e-discovery, you should associate with counsel who does, or with a consultant who does. That's kind of the big takeaway. And then it creates effectively a checklist of what you should be knowledgeable about. And it goes from preservation all the way through production, with forms of production and request and that sort of workflow when it comes to e-discovery. So I think it's a good thing, but it goes to the heart of the different models that we have. Small and mid-sized firms, I don't know if all the lawyers will bone up and study hard to get really knowledgeable about the basics of e-discovery. I think they should. I do think it's part of their duty of competency, but I could see a lot of those folks talking to service providers or attorneys like me for help. I totally see that happening. On the other extreme, I see with the larger and the true mid-sized firms, either developing the expertise in-house or having that trusted partner that they are looking to basically on every case.
No, and I agree. And I think the small firms must embrace this, because otherwise they're going to begin to lose business because they're not understanding and not being able to communicate that. And so it's not a commoditized service, as we've talked about in the past, where it's just here, just do this. It has to have a lot more thought process and involvement by the legal team, and they must understand based upon the decisions that they're making. and you touched on it a little bit earlier about even the search term development. It's a very, complex approach, and you've got to understand what a tool can use, as well as just even being able to frame a proper search. And so, the days of lawyers not being involved, I think, are long gone.
Well, there's huge issues with electronic discovery because it's discovery. It's in both civil and criminal litigation. And there are lawyers that you go see for, if you want a will done, you go to somebody who understands wills and trusts. If you got a speeding ticket because you're talking on your phone while driving and you violated a couple laws, you're going to go see a criminal defense attorney about what to do. If you have a breach of contract, you go see a business lit attorney. All of them need to understand how discovery works, and criminal discovery is a little different than civil discovery, but the basics are still there, and doing the request and knowing what you want and being able to search for it and find it, and there's no escaping discovery. And the fact that everyone's running around with smartphones and cloud computing hitting everybody's life, the idea that you can somehow avoid it in the practice of law is just an unrealistic expectation. So this is why I think those rules are important and why I think they should go through in California. But the bigger issue is, how do you practice? And I think the three models here outline three different ways to do it, and all have different variations on how they can do it.
No, and I totally agree. And even applying what you just said in the communication, and I think at times technology scares lawyers, but I think they're going to have to get much better at that. And then with the cross-border discovery, when you've got a law firm here with one in the EU and corporations that are international, the ability to be able to know, for instance, the Data Protection Act in the EU. What does that mean? It's not as though in the old days people could just, I'm just going to take the data that I collect and ship it to the States and have it processed. I mean, that's, those are the mistakes that can sink, a very large piece of litigation. And so those are the kind of things that they need to have the expertise in-house, whether it's through a consultant or domain expertise within the firm, or utilizing and leveraging a supplier.
Well, that also gets into other specialized areas like the Foreign Corrupt Practices Act and those type of investigations, and figuring out if you had a salesperson in one of the hot zones for fraud that was greasing the skids for business to go through in Russia, Asia, you pick one of the areas that's on the fraud index, and what happens from that. A lawyer sitting in any state that has a corporation that's doing business abroad that's now subject to one of these investigations, they have to know what they're doing. They have to know how to go out and look for it, and that's normally going to involve someone performing those searches, and it's going to be at a forensic level.
Absolutely. That's even going out and collecting that data to even start it. What are the rules of that specific country in order for them to be allowed to, even if you process and host the data within that particular country, whether it's the EU, what are the specific rules of one of the countries within the EU to even collect that particular data? What are the authorizations that must be sought and approved before that data can even be taken off premise? So there's just a tremendous amount of details that must be thought through in this area.
Exactly, and again, it's a unique intersection of legal responsibilities and the technical and how to go out and get it. Because let's say that all the communications that you had with the foreign country are also backed up in Texas. That makes getting them a lot easier because we're not going abroad to do it.
Right.
But are there other issues at play? Because, so again, it's a fascinating topic, and we could go off on that one for about an hour.
Right.
But with that, any other thoughts on how these different methodologies can help attorneys practice law and be competent?
I think in my closing, I would say that don't think of one model. Don't think of outsourcing, insourcing, or co-sourcing. Think of what's the best model that's going to work for your particular law firm. And I think at times firms believe they must do it in-house just because that's the thing they must do. But I think that with the combinations we've talked about and ending, frankly, in co-sourcing, that can get them to the to the point that makes them a much more successful firm, as well as being able to handle this big data and reducing the costs for their clients, which is the big driving force right now.
Well, and I agree with everything you just said. And for lawyers, they're used to two different ideologies when it comes to figuring out solutions. One point of view is they want to know the answer, because what's the rule, what's the law, and what's the test? And lawyers are very, very good at going A, plus B, equals C. We're very good at that. The other thing that we're very good at accepting is it depends. We're very used to that answer, which gets to the heart of what model you use will depend on the client and the situation, the size of the firm, and the case. So it's not a bright line rule. It truly is an it depends answer.
Agree. Totally agree.
So with that, David, my friend, thank you very much. I want to thank Planet Data for sponsoring this podcast, and I truly hope all is well and look forward to seeing you in the future.
Thank you, Josh.
Take care, everyone.